salvage us from where we are.
Senate has disclosed that 74 lawmakers out of the 109 members of the Red Chamber voted for the state of emergency rule in Rivers State. The Senate spokesman, Senator Yemi Agaramodu, representing Ekiti South Senatorial District, disclosed this to newsmen over the weekend at his country home in Ilawe, Ekiti State. In his words, when the question was put to those in support of the emergency rule in Rivers State, all of them said yes, and nobody said nay after they had discussed the matter. It is very unfortunate that everybody in Nigeria wants to interpret the rules and the constitution of the Nigeria the way they like. Agaramodu condemned Nigerians' interpretation of the rules and standing orders of the National Assembly, who alleged that they were designed to favor their line of action and position. The rules say it must be through the closed door session when issues of security matters are discussed, that you cannot be debating it in the open globally. We did not bend the rules, we did what we needed to do. Personal feelings are not law or status. We debated it and we all agreed at the closed door session that we were all supporting the emergency rule in Rivers State. After the debate, we increased the list of 3 more clues that are outside what the presidency brought to the National Assembly. It may not last 6 months if there are feelings that the atmosphere is conducive. The administrator will not only be reporting to the presidency, but the National Assembly shall continue to continuously adjudicate and do oversight functions over the administration in Rivers State. That eminent Nigerians be set up in the form of a committee to bring all warring factions together and adjudicate and try to mediate among them and bring peace and make a report to the presidency and the National Assembly. In Rivers State, the problem was caused by the governor and the House of Assembly members, which means that there was no governance in the state, where the majority of the 32 lawmakers could not make laws for the state, but only 3 loyal to the governor. Senator Agaramodu, however, debunks the insinuations that the National Assembly are rubber-stamped lawmakers. Asems, what is your take on this reaction by the Senate?
Somewhat is very correct. You see, many people think that emotions, is what politics is all about. You see, a politician or politics is not about emotions. It's not about sentiment. Especially the Nigerian archaic and arcane, type of politics that we play. Let me tell you something. I have sat in this studio a number of times and I said the Nigerian, political ecosystem is akin to that of the Serengeti, the Okavango. These are territories ruled by beasts. There are no laws. In the Okavango, in the Serengeti, there are no laws. The only law that goes sway in the Serengeti is the law of survival. So every politician, the Nigerian politician, fight for survival. The battle, let me be very open, the battle between whether sinful power, yes or wicked, is all about struggle for power. People should not deceive themselves. And there's this particular insinuation which is very diabolic, that other people have spewed all over the place. They say it's an angel. One is an angel, the other one is a demon. See, there are no angels in the political ecosystem in Nigeria. And now, coming back to the declaration of state of emergency, this is not the first time. A lot of Nigerians do not know that in 1962, we had a similar situation of this nature. And that is where the Western Regional House of Assembly was polarized. And a vote of no confidence was passed on one Samuel Ladoke Akintola. And in a parliamentary system of government, once a vote of no confidence is placed on the Prime Minister, whoever, or the Premier, automatically the Premier must resign or abdicate or leave the office. This was not, Akintola refused to do that. Then you follow that the then Governor General, Governor General of that particular Western region, his name is Adelemi, one time Ooni of Ife, who was the president, let me use the word president of the Western region. What he did was to come in and now appoint one Adebenro to take over from Akintola as the premier of Western Region because of by vote of that whatever, no confidence. Now, where I'm driving at is that Akintola went to the Supreme Court, the local Supreme Court, the Western Region Supreme Court in Ibadan, where they could challenge, the parliament, just like people are doing now, the National Assembly, where they could challenge that Section 33, Sub 10 of the Western Region, Constitution states that for you to remove a premier, you have to have 2/3 votes. And what that 2/3 votes mean is that voting either by electronic means or by physical, voting pattern. But in this case, that the parliament in the Western Region did not do actual voting of either raising up your hand or casting a ballot. That they only did their voting by issuing 2/3 signatures. That is, instead of voice vote or whatever, signatures were collected and it got 2/3 to remove Akintola from office. The Western Region Supreme Court, affirmed Akintola's position and now said Akintola should be reinstated. But Adebayo and his group were not satisfied. They now had to appeal to the Privy Council in UK. As at that time, Nigeria had not had their Supreme Court that we have today. The Privy Council in UK was the one deciding matters. For those students of law, who read law, and those listening to me today, law students, you hear about the Adebayo case. It's a popular constitutional matter. Section 33 sub 10 is what was the issue there. Now, the Privy Council now returned, and said that whether it was by signature, whether it was by voice vote, whether it was by casting or ballot, that a 2/3 was extracted from the parliamentary house, that it is valid, that the premier was validly removed from office. And there was no other court to appeal to. But then Adebayo came back to show they have gotten a superior judgment. Akintola had already tinkered in Section 33 sub 10 of the 1962 Constitution of Western Region. That was what created that particular mess. He refused to leave, and the people, there was this kind of same situation that we have today now, where Sifubara and the parliament are dragging. Now, what happened was that Tafawa Balewa, by virtue of Section 65 sub 1 of the then Independence Constitution, now had to declare state of emergency in Western Region, which later led to what they refer to as the Wild Wild West. That is where the origin of the declaration of emergency, came. Now, a matter came before the courts, which they have not been able to resolve today. And that matter is this: the under Section 65 sub 1, or under Section 65 as a whole, that the president, the prime minister of Nigeria, do not have the premature authority consent to remove, a premier of any of the regional states, as the case may be. That matter was unresolved till 1979. This same section was retained till 1999. Section 305 now came in again, that the president can declare state of emergency. Now, a lot have argued that even if the president had the premature authority to do whatever, that the National Assembly, being the House of Reps and House of Senate, can also filibuster, the president, and say no, you cannot even declare it because there's no war in real estate. Why did you declare that state of emergency? So they are going to say no, we are not going to give you that vote, 2/3 or whatever vote that they needed for you to escape to. That has become the controversy before you today, saying that the Senate ought to do what they call either electronic voting or voting, which is the actual ballot posting, as the case may be. But they didn't do that. But they did they used what they call voice vote, yes or nay, as the case may be. Now, what this man is talking about is that part of the standing rules of the Senate is that they can do a closed-door meeting, they can do a committee of the whole house as decided by their rules, and now decide that voting, in the parliament is either by electronic means, it is also by ballot posting, it is also by yes or no, which is acceptable in the universal parliamentarian conduct and procedure, as the case may be. That what they did on that day was that 74 senators said yes. Why? And there was nobody that said no. So that it was in order and very proper. In my own opinion, I support his own, a trajectory of explanation. The reason is not far-fetched, in the sense that if you want to conduct votes in the House, it is decided by the House itself, as the case may be. Now, if all plenary were to be arranged, and not all members, came in, who would have served as the naysayers? The naysayers refused to come to the House. Some of them sat back in their parlors, so sat back in their houses, drinking pepper soup and jollof rice, while they were supposed to be in the Parliament at that time to go and shout nay. They never went there. Let their voices be higher than the yes say, as the case may be. So if you didn't go to perform that duty, and it behoves on the Speaker or the President of Senate to now say the ayes have it, what right do you now have to now question that? That is what this man here is talking about. So we have seen that, and we want Nigerians not to sit in street corners to begin to condemn, what has there. We have said this before now. When Obasanjo declared this of emergency, what might happen? The Supreme Court said something about state of emergency, and whether the president has the powers to so declare. Now, the Supreme Court did not even listen to that particular matter in the plateau scenario. They said that those who went to court did not have what they call locus standard to even challenge the process, as the case may be. Now, litanies of matters have been filed. I hope it will not still go the same way, because Supreme Court cannot overrule themselves when they make a decision that if you want to bring an action to challenge the state of emergency, you have to get permission from the sole administrator. That was what happened in the plateau case. When Dari and the rest went to court, they said, yes, you came to us, but we do not have jurisdiction to attend this matter because you never took permission from Chris Ali, who was the sole administrator. How did that happen? When they filed, Chris Ali, who was the sole administrator, filed a joinder and filed a counter, and now there is a preliminary objection to Dari and the House of Assembly members that were suspended. It was that preliminary objection, what we call the PO, that was upheld by the Supreme Court of Nigeria in 2004, 2001, 2004. It's on record, and that particular decision has not been overturned. So I don't know exactly where Nigerians are getting these vibes of this really go through. Go to court and challenge if you feel that things of this nature have been done. Okay. So I believe I support what the senator said.
All right, I'm starting with two things. First of all, I will ask you two questions.
Yes.
Then I will start from the last.
Yes.
The last statement you made about the sole administrator will have to grant permission for any legal action against his administration or him.
Yes.
Now, in Rivers State, this matter has been taken to court.
Yes.
Some persons have taken this state of emergency to court. Now, you're saying that the court does not have the jurisdiction to entertain this matter if the sole administrator does not permit.
Yes, that is what the Supreme Court said. In the Joshua Dariye was, removed.
In the matter of Joshua Dariye,
yes,
in Supreme Court.
In Supreme Court, is there. I was looking for the citation. I cited this. I can see and give it over to you at the end of the program.
Right.
It is a decision of the Supreme Court, and it was not just, it was a unanimous decision that the court lacked that jurisdiction because Dariye, that was suspended as governor, the 24 House of Assembly members, the House of Assembly members of Plateau State that were suspended by that emergency rule, that came to court and challenged, what Obasanjo did at that time. Supreme Court said that they cannot entertain the matter because one, that Dariye is a suspended governor, that the only person that can give that premature for him to have locals to challenge is the sole administrator. It may look very well in terms of hermeneutics. What does that mean? Interpretation, law interpretation. Hermeneutics is interpretation of the Bible and of the law. So it depends on how you interpret it. But this is what the Supreme Court said, cast in stone. And I dare not to challenge me on that today. I will give the citation to you if I leave the studio, as the case may be. And that is what the Supreme Court said. Why? What happened was this. When the matter was before the court, the case are really a fashion. And the sole administrator of the Plateau State at that time filed to be joined. And I believe that is what is going to happen in this case. For matters that are already in court against the sole administrator of Rivers State, that is the whatever is the Abbas or whatever is the call him. You know what's going to happen? The lawyers will go and file and say they want to file a joinder and raise the appeal that I did not give the permission to Governor Sefubara, to bring the action, because I am the acting governor of the state right now. So based on the precedent of the Supreme Court, it's very clear, cast in stone. So until the Supreme Court now override themselves, then we begin to have a different, pedestal. I have challenged in Lagos. When I was before the station, we did a psychological evaluation, forensic, pathological evaluation of what exactly is going on in Rivers State. And I said so, and all lawyers that were there, vocally agreed with me that the situation is what the Supreme Court has said. And until that is vacated, or when the Supreme Court now override themselves, then we can begin to have a semblance of maybe lifting the state of emergency, which I doubt. Through the courts, it will be very, very, very difficult. It will be very difficult, except the Supreme Court overrule themselves or override themselves.
And by the time this matter will trail down to the Supreme Court, it's well. Now, the next question I want to ask you is with regards to you said you support the statement of the Senate when it comes to the voice vote.
Absolutely, yes. That is what the law says.
Now, one of the public outrage was that it was through voice vote.
Yes.
And we have seen it happen severally in when we watch plenary, where you hear nay and you hear yea, and it appears that the nay is louder than the yea, but then the yea takes the day. Situations like that, but probably it's just our ears, probably we didn't hear well, but from what we hear, you hear the nay being louder than the yea, and somehow the yea, by some miraculous twist of events, will have their way. Now, moving forward, this was televised. And Nigerians that watched that plenary saw that happen, which gave rise to that outrage, and outcry against voice vote. But now the Senate spokesperson is coming out to say that this decision, was taken in a closed door session. That appears to contradict what we observed, because if it was a closed door session, the media won't be allowed in that session. So, are they saying that the voice vote we witnessed was a completely legislative activity that happened, and then after all that, they now had the closed door session where the state of emergency was passed? Because the reaction we've had so far is not as a result of whatever happened in the closed door session, because we did not witness that, but the reaction is as a result of the one that was televised that we all saw.
The point is this. The Senate, what the man was referring to is that which is allowed in parliaments all over the world. Parliaments all over the world, you have people they call the lobbyists.
Yes.
That is where pressure groups also come in. Some companies may come and lobby the parliament for them to pass environmental laws that will favor them. Some companies or individuals can also come and shoot down and lobby to bring down a particular bill, and they are called filibusters. The filibusters work against the lobbyists. The lobbyists work against the filibusters. That is what happens in all parliaments of the world. Now, when matters are to come before the open glare, there are closed door meetings, what we call horse trading. You understand? Because people just think that politics is engineering or whatever that once you remove one bolt, you must put another bolt of the same kind without change, straight jacket. It's not so. Politics is about bargaining. Politics is about collective bargaining, understanding, mutual understanding. That is why they say that in politics, there are no permanent friends or enemies, but permanent interests. So if you are in parliament, like what happened, in the emergency, whatever, we all know that the Akpabio Senate, as we refer to it, is a Senate that has been lobbied by the executive arm of government. A lot happened. Even in the United States, where we draw some of our democratic vibes from. Do you know that there are times that the president will want to lobby a section of the Senate? A good one, for instance, now is the one that Donald Trump has said that he is not joking about a top 10. And he has already pinpointed one or two people fixed in the Congress to push that particular vibe. If at the end of the day he is able to get the top 10, that because that the president has put overbearing influence on the Congress, as the case may be. So in Nigeria here, what happened that day is that you have your closed door meeting. When you have the closed door meeting, you are supposed to do your horse trading. Those who want the state of emergency to remain, we say we want it to be. Those who do not want it also have the right to say no, we are going to resist this. But honestly speaking, for those who were against the state of emergency, they chickened out. And I'm saying this, without any fear of contradiction. They chickened out. I heard that most of them did not even go. They sat in their various houses and allowed the yes men to have the day. The question we are asking is that if 74 people voted, in favor of the state of emergency, where were the other members of the Senate? 30-something members or even 20-something members, where were they? Were they in the Senate precinct or premises or in their various houses? These are questions their constituency should ask them. That is number one. Number two is that, like I've seen in the Adebero case, where it went to the Privy Council, which was the highest court at that time, the equivalent of Supreme Court that we have today, because our Supreme Court was established in 1963. That was when it was established. This matter came before that establishment of Supreme Court. Now they said that any manner the parliament decide to extract, their vote is deemed to be what? Valid vote and procedure. Whether it is by shouting, whether it is by raising up your hands, whether it is by posting your ballot, whether it is by electronic means, etc., as the case may be, it is acceptable and accepted worldwide. So if the naysayers or the yeasayers, had the day, and the gavel is now struck by, the speaker or the president of Senate, well, it depends on the way you see it. Some say he has compromised, of course. If he has compromised, you can take him to court, you can prove it, and bring his, a posture figurines in the public down. But these are just mere insinuations here and there. But I believe that what happened that day does happen in any parliament. That's why you find that in parliaments they fight. In India, I remember when the state of emergency was to be declared in one of the regions in India, the parliament they enter into a war, they fought themselves. So you see parliamentarians throwing chairs. You see them also coming together to sit and say, we want this to happen. So if majority, said they wanted it to happen, whether by hook or by crook, we cannot go there and begin to say or force them not to do. The only thing we can do as citizens is for us, if you are very cocksure that you have facts, you go to court and challenge the process and procedure.
All right, very well. Before we move over to Edo State Tribunal, I want to ask you a question. The controversies surrounding the emergency rule, it's not even the emergency rule itself, but the fact that an elected governor and House of Assembly member were suspended by the president, and I have gone through the Constitution and I'm yet to see where the president has the authority to suspend an elected governor and House of Assembly member. What is your take?
My take is just similar to yours. Section 305. If you read, because I am not going to serialize, I'm going to read or take section 305 and do what I call community reading of section 305. Now you now go to section 11 of the 1999 Constitution. You now go to section, I think section 41 also, that talks about suspension of rights during a state of emergency. Now, if you go through all this combined and community reading of this, yes, the president or the executive president does not have the premature authority to do what? To remove the sitting governor, to also dismantle and lobotomize, a house of assembly, which is the legislature. The reason is not far-fetched, because Baron Stanley Montesquieu talks about separation of powers. That executive, legislature, judicature, these are the three arms of government, and these three arms must work independently of each other, but they act as oversight function against the other to give a proper government and governance. Now, that if one is taken off, it now becomes a problem. In River State, the executive arm has been emasculated, legislative arm has been what? Lobotomized. The only one that is still breathing life and in the intensive care unit is the judiciary and judicature. And if you look at the judicature right now, the CJ of River State has said all judges should do what? Go on a Easter vacation. They should go on Easter vacation and resume 29. So they are even working on spindle legs, because they don't even know whether the president can even suspend the judicature in River State, as the case may be. So that is the situation. Now, there is no place in the Constitution under the law that gives the president the powers to so do. But there are controversies in that section 305. Right. The question I have been asking, when you say that the president can sit in his house, can sit with his kitchen cabinet, jollophing and pepper souping, and they don't see that to now say, River State, we are going to declare an emergency tomorrow there. The only thing I will do, call the Attorney General of the Federation to come and put that in the Gazette. The president will not do the gazetting. Then, once it is gazetted, the president will not do what now? Announce a state of emergency. Now, that 305 says that once you do that gazetting, the president has the right to declare a state of emergency. But there's a place that beats me hollow that says in that particular gazette that the president must take what we call details. That is details of the state of emergency, which all the presidents that have done this have stated. Obasanjo said that it was because of the crisis between the communities or whatever. That was why he did that, and the governor could not take control. That is the details he gave in the two Ekiti and Plateau state. Then Tinubu this year now have to fill in the details, saying that governance has broken down in River State. That is the details he put in the Gazette. That governance has broken down in River State, and that he didn't say that River State there is fighting or killings. He didn't say that governance has broken down and that there is a likelihood of breakdown of peace and order. So this is the leeway the presidents have escaped to now insert in the details the removal of a sitting governor. So by precedent, it is allowed in Nigeria, but by law, the president can also do. But if you ask the present government of today of Tinubu, he is going to tell you that Obasanjo did that in Plateau State, he did that in Ekiti State, Jonathan did that in some part of Borno State. Are you aware that even when Jonathan did that in Borno State, he did not suspend the governor, he did not suspend the local government chairman? But even as it is, are you aware that Sheriff and the rest challenged Jonathan to the Supreme Court whether the president has the imprimatur to so do and declare a state of emergency. You know what the Supreme Court came and said that whenever national security is threatened, the powers of the president is above, is just Olympian. So it says the president, the moment security reports get to the president that there is going to be threat to national security, it means that President Tinubu can wake up and do what? Declare a state of emergency in any part of the country it feels that that threat is coming from. Supreme Court said it in that particular case. That when it gets to that issue of declaration of the state of emergency, that it is the president that has that particular consent. So, and discretion. So a sitting president who feels that state A is belligerent, state A is activistic to his persona and his programs, he can invoke Section 305 and can be misused, to do what, to undo an enemy state, an enemy politician. That is what the state of emergency has been used thus far from 1960 to 2025. We've had 3 of them, and each of them, look at what has happened. If you look at it, Tafawa Balewa was in opposition because the action group was the particular state and a party ruling Western region. Tafawa Balewa was of the ZMPC, they called that their political party. So he wanted to claim the Western region and destabilize it and put his stooges in power so that there will be a semblance of submission of that particular region to the federal might. The same Obasanjo did. He uses against Dariye, who was his enemy, who challenged him openly. He used that against Ayofa Yoshi of Ekiti State to now declare. Tinubu now came also, and I saw a reason why he has to do that. Whether covertly or overtly working with somebody outside, I don't know, but he had to work on that to revoke, what happened. By law, he does not have such imprimatur, but by precedent, he has so many precedents to cite. If we were to be in the law court, I would say I have 3 or 4 precedents which I have to cite to support my case. And the president cited, situations of that nature to declare that and remove his name.
But Goodluck Jonathan did not.
He did it. It's only one. He didn't suspend because he was not, maybe he didn't want to use his full powers. Let me tell you, we practice what they call presidential system of government. And in a presidential system of government, the president is all-knowing. In fact, the president is a spirit. The president is a more, in Igbo we call it more, when it's a deity. He's a big, he can wake up in the morning and disappear. So he belongs to the spiritual world. So the presidential system of government so includes the president. That is why President Tinubu can sit down and even say today, I have cancelled that state of emergency. Nobody will challenge him. So because it is the president that has all the powers. I have gone through all the sections and the 399 pages of the Nigerian Constitution 1999. And I found that a president of Nigeria is the most powerful president in the world. If we had arms and ammunition like nuclear warheads, Nigeria would have colonized the rest of the world. Because our president is so strong. Our president is so powerful, not because he's a superhuman being, but the Constitution. If you check all through 399 pages of that Constitution, about 300 pages gives powers to a presidential power and the president of Nigeria to operate. That is why they become, behemoths and they always stand in Mount Olympus, as the case may be. So I don't know how we are going to overcome this.
All right, very well. When you now building on your last statement, when you say you don't know how we are going to overcome this, now meaning the dedication of a president according to the Constitution. Now, in the the statement of the spokesperson, he debunks the fact that the Senate is a rubber stamp Senate, right? But then one would say the Senate approved this unconstitutionality. If the constitution does not empower the president to suspend a sitting governor, an elected governor and House of Assembly member, one would say, why did the Senate approve of that move by the president? Because even though the president is powerful, the law has also made room for checks and balances. Would you say that the Senate did due diligence in this particular move?
Well, for me, what I feel is this: I'm not a member of the National Assembly. I'm not a legislator or a senator, as the case may be. But the essence of, legislating is that, while you see they say 360 members, 109 members in the Senate, put all together by 500 something members of the National Assembly we have in Nigeria. The reason the Constitution say 2/3 majority, the Constitution never said that if you want to achieve that 2/3 majority to get a vote or whatever to pass through, that the people must be standing or queuing in a place. They only said if you can get 2/3 majority. Now, coming to the state of emergency that was declared, what did that subsection say? It says that the president, after gazetting, has to send that particular gazette with the details to the National Assembly. That the National Assembly within 2 days, of the president submitting that gazette to the National Assembly, must take a decision. That is if they are already sitting. But if they are on recess and the matter that came up, like it happened in Obasanjo's period, within 10 days, the National Assembly must come back from their recess and sit over that particular deliberation and either accept or not to accept. It gives them the discretion to either accept or not to accept. How do you not do that to not accept is the question that many of us cannot answer. Now, if the Senate president, like we have right now, whom many perceive to be a friend of the president and executive, is seated, in the hallowed chamber, and you want to talk to be extracted from members, then what do you expect next? Are you saying he's going to challenge, the president and say he's not going to do that as his yes man? That will be very difficult in the Nigerian situation, because what the kind of politics we play in Nigeria is very transactional. Let us not deceive ourselves. It is transactional. So the Senate president will look at, it's a transaction between me and the president. What am I going to get from here if I give the president his leeway to have his way? So personal, suasion most times override the decision of the general and collective. That is what has happened. But we Nigerians, we have the right to, condemn what they have done. They also have the right to say yes or no. And if they have said they agreed, and nobody in the Senate has come out, even the radical senators we have who have said no, we didn't follow due process, then we are challenging this. Then who am I to challenge what they have done in the House of Senate?
All right, very well.